Having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston, Lieutenant Bob Commonwealth. Draw near, give attendance to the Shami. Now sitting Commonwealth in action, this court is open to be seated.
I don't know. Still having breakfast. Good morning. Welcome to the Appeals Court. I'm Justice Meade. To my right is Justice Blake, and to my left is Justice Brennan. We'll be the panel for all of the cases today. If you haven't been here before, I think most of you have. You know that each side has 15 minutes. We've read everything. We don't entertain rebuttal. My best advice is to get right to the point. With that, I'll call our first case, 23P449, Commonwealth versus Melendez. Mr. Locke.
Good morning. May it please the Court. Michael Locke for the Commonwealth. The Commonwealth asked this Court to reverse the motion judge's order of suppression regarding the firearm, as there was probable cause to search this vehicle for evidence of a shooting. When officers arrived, they had already been dispatched for a call for a gunshot victim. They showed up at the scene. They confirmed there was a gunshot victim at the scene. He was slumped outside the car door was open, there was blood all over the place, including blood in the front seat of that car. They also spoke with individuals who were at the scene who said that the defendant had just arrived in the car and no one else had driven him, that he was the driver of the vehicle. Based on these facts, the officers had probable cause to search that car for evidence of a crime, that being ABDW, because the defendant had been shot. The defendant himself also told the officers that when they arrived that he had been shot by someone else down the street. So there's probable cause to believe a crime.
Did he say he had been shot by somebody else? They asked him, buddy, do you know who did this? And he didn't say anything.
I think at some point he did say that someone shot me down the street.
Was that before he was loaded on the gurney? Because I watched the video again this morning, and I didn't hear that.
Yeah, I think maybe it came in the testimony, and maybe it's not in the video, but I believe during the testimony he did say that someone had shot him down the street. In either case, even if...
Down the street part, yes. It's
right.
the someone that I'm questioning.
I guess it might have come in during the testimony, not from the body cam. But either way, I think there's still probable cause. He has been shot. He's clearly been shot.
Let me ask, you argue improper storage. Are you still pushing that as a possible crime, or, which isn't mentioned, discharge of a firearm within 500 feet of a building?
Those possibly could also be other crimes here, but I think the
most obvious.
The most obvious crime is ABDW, that he had been shot by somebody.
Even if they all thought he shot himself?
Right. Given the fact, I do believe at some point he says that someone else shot him. I believe that is in the record.
Another question, slightly unrelated, is you seem to have abandoned your inventory argument that the motion attorney made. I'm trying to understand that, because it seems to me that it's a crime scene. I mean, if the defendant passed away on the way to the hospital, you got a bloody interior of a car, and then if they follow up and get witnesses who say, oh, somebody, the passenger leaned over and shot him in the leg, because that's what it looks like on the inside of the leg, and then at trial, the defense attorney crosses-examines the police, say, well, you know, did you get blood from the car? Did you see if the fingerprints inside the car? Oh, no, we just left it there, and somebody, I don't know what happened to it. I mean,
I agree with Your Honor, but I think that goes to the probable cause argument, the automobile exception. The tow, how it was argued below, was that it was an inventory of they could tow the car because it was improperly parked in that area.
Yeah, what about the no trespassing sign that was up on the wall? And I think I saw that in one of the videos. Let me see, that was in, at 3:57:48, they pan it in, it looks like body camera 3. It says no trespassing or loitering, no consumption of alcohol, but alcoholic beverages are permitted. Police take notice.
I agree with that, Your Honor, but here the motion judge made findings of credibility that the defendant had a right to park there, and I think based on the posture that this is in, that those findings are unacceptable. As the defendant testified here, he made a credibility determination.
Based on his friend that the witnesses says isn't here?
Correct, Your Honor.
Okay. And so you're not arguing it, just I'm clear, so
right.
you're not arguing that they had the right to secure that crime scene, if you will, transport it to the police station and then get a search warrant, because it wasn't made.
They could, but as a result of the automobile exception, there was probable cause that car itself is evidence of the crime.
Okay.
As I said, I think below the way it was argued was more that it was parked improperly and then the police could tow it because it was kind of argued as if it was like a motor vehicle stop.
Right.
And I don't think the way the motion
Mr. Locke,
yes.
what do we make of Justice McDonough's finding that the defendant had, the police had exclusive control of the defendant, the vehicle, and the scene as it goes to the question of security concerns?
So I don't believe the court has to defer to Judge McDonough's findings because this is all on the body cam. And Judge McDonough didn't make any credibility findings as to that in his motion. And even if he did, I think,
He didn't say that in his motion?
I'm sorry, Your Honor?
He didn't say that in his motion?
I don't believe he made credibility, a specific credibility.
I meant, did he make those findings about control?
He did make those findings, and I don't think this court has to defer to them because I think he made them off of the body cam.
Well, don't we have to accept them unless they're clearly erroneous, though?
Unless Your Honors are in the same position as Judge McDonough because he made those findings based off of the video of the body cam.
I see. So you're saying we review it de novo?
Correct. And even, I would say, even if,
But he did take testimony, though.
he did, yes, he
Including
did,
the defendant, right?
including the defendant, that's correct. And I would say even if it was a clear error standard, I think it is clear error here. If you watch the body cam video, you can see that there's a group of people surrounding that car, workers from, it looked like what I would assume is workers from that garage area. And
Like an army of police officers there.
correct, there are, yes.
So did any of the witnesses testify about securing the scene? I assume the defendant did not testify that police had secured him in the scene, but
Correct.
did the police testify to that?
I don't think there was any direct testimony that the scene was secured. Again, we have the body cam video here, and I think,
No, I'm just wondering, because obviously if a witness testified to it, we'd have to defer to that unless
Correct.
it was clearly erroneous. But the
Correct.
body cam, you're right, we would look at that de novo.
correct. And I think a lot of this discussion goes to the frisk of the car, like Terry stop of the car. Commonwealth's initial argument is there's probable cause that they would find evidence of this crime in that car. We know there was blood in the car. That's evidence of this crime. I think that full stop is PC to get into that car under the automobile exception.
When he's on the ground, before they move him to the gurney, his left arm is reaching into the car?
You could interpret that as what is happening, Your Honor.
And from where that arm appears to be, where is the gun located? How close in proximity to his arm?
The gun's found underneath the front passenger seat, and he's outside the front driver's seat. So it would be a long stretch, but they didn't know where the gun was at that time yet.
And while they're working on him, there's the first body cam, which I think is the female officer.
I believe that's correct.
You see a bunch of police officers on the passenger side looking in the windows. Nobody saw a gun at that point. Is that right?
No testimony as to that, Your Honor.
And is it fair to say the gun was tucked under the seat?
Based on my review of the body cam, it seemed like it was a little tucked under that front passenger seat.
Judge McDonough found that the defendant was uncooperative. If we don't agree with that, does that matter?
No. I mean, I think it might slightly take away from the Commonwealth's argument, but again, I think...
There's no question, right, that he's writhing in pain.
Right, yes. Yeah, he has certainly been shot. Yes, yeah.
And is he non-cooperative, or is he writhing in pain and unable to answer questions?
I think it's a little bit of both. I think he certainly is under a decent amount of pain, but he is able to give some type of answers, and I think those answers, now knowing now that the gun is in the car, I think that was strategic on his part. But
Would it be different if instead of saying he had been shot down the street, he hadn't said anything, so they didn't know where he had been shot?
I think that adds to the Commonwealth's position, because now the firearm might be in that car. If he had said shot down the street, which I think he said, if he didn't, he might not have. But
I think he said that. I didn't hear on the
Okay.
audio cam that it was someone else.
Right. So here, the officers had no evidence of where he'd been shot. He said down the street, but he didn't say whether or not it was in the car or not. And obviously, this happened in a very short period of time because it's a serious...
Hypothetically, he could have been shot, then got in the car, drove.
So theoretically, yes. But here, we're talking about probable cause, we're talking about common sense, and I think once you start getting to hypotheticals, I think we kind of go a little further than probable
At what
cause.
point is it fair to say that they figured out he shot himself?
Once they found the gun. I think that's probably... I think they had a reasonable suspicion that he might have shot himself, that gun was in that car, but I don't think that they knew it until they pulled the gun out, obviously.
Did they formulate that suspicion before they searched the car?
Reasonable suspicion, yes. I think there was reasonable suspicion that there was a firearm in that car before they searched the car.
And that's based on the location of the wound, or?
Right, yeah, and the fact that people nearby had told officers that he had just driven up himself. I think it might be different if, say, he had been dropped off, or if someone else had been driving the car and like had taken off. I think that would kind of detract from reasonable suspicion here. But the fact that it was the defendant himself that pulled up and fell out of the car, it's obviously a recent wound, so I think there was reasonable suspicion that he might have shot himself and that gun was still in that car. If there are no additional questions, the Commonwealth would ask the court to reverse the motion judge's order.
Seeing none, thank you.
Thank you.
Ms. Allen.
Good morning, Your Honors. Ashley Allen on behalf of the defendant appellee, Mark Melendez. First, I want to address the judge's standard of review when it comes to supplementing the record with documentary evidence, which we have in this case, in which the Commonwealth's arguing you should do. They did not argue clear error standard. So the findings of—
They did not argue what?
They did not argue clear error standard for any of the finding of facts. For this court to then supplement— you can supplement the judge's findings based on documentary evidence, but if it's ever contradicted, we can't do that. And so that the findings that they're arguing should be—
Well, but hypothetically, we both look at the same video, and let's take it out of this case. Judge McDonough says the light was red, and I watched the video and the light was green. Do I have to defer to the light being red?
I think in this circumstance, one, the Commonwealth would have argued clear error there, and there it's by watching the video, you're able to and the testimony doesn't matter for that fact, then I think, yes, you could change that.
Because that would be a clearly erroneous finding.
Yes, but at the same time, you have, it's undisputed. It's not where here we have disputes and there is testimony from these officers. And I think the biggest finding of the lower court is that there wasn't a safety concern. And there was testimony that the scene was secured, and when officers arrived, that's what they were doing. Especially, I believe it was Officer Coburn that testified when he arrived that the scene was secured. The defendant was having aid rendered to him. He was outside his vehicle. There was a multitude of officers surrounding him.
Did he arrive before they searched the car?
He did arrive before they searched the car. So at the time Officer Coburn arrived, the defendant was already outside of his vehicle, the scene was secured, and they had yet to search the vehicle. That's when they announced at some point within maybe, I think, 5 minutes of Officer Coburn's arrival that, hey, we need to do a protective sweep.
So can I ask, this is an objectively reasonable officer test, right? It's not whether they subjectively were in fear.
I'm sorry. I didn't hear.
Subjective fear is an objectively reasonable officer in the officer's position.
I think here
What's the legal standard, I guess my question.
I think it's a reasonable standard position. Would a reasonable person in this circumstance believe that there was a firearm in this vehicle? And there's no evidence whatsoever of that. And the Commonwealth admits there's no evidence that for a reasonable belief that this person shot himself. I know there might have been a hunch or a suspicion, but that's not enough in the reasonable suspicion calculus.
So I'm just trying to walk it through and understand it, because I guess when I look at the video, I see police roll up and see a guy on his side with kind of his arm inside the car. They see some other guy that they don't even know, the guy in the white T-shirt, reach inside the car, literally lean inside and reach inside the car. It looks like he grabs his cell phone and hands it off to your client. And then he's lying on the ground being treated, and clearly there's 6, 7, 8 officers who are pretty matter-of-fact about it, which, whether it's a product of their actual fear or whether it's a product of they see this every day in Springfield, we can all speculate. And at that point, I guess what I'm trying, I mean, they don't know yet. They haven't run your client's record. For all they know, he's lying on the ground thinking, oh gosh, they're going to find my murder warrant, which of course didn't exist. And you don't think it's incumbent upon them, and then there's 5 other people standing around kind of 15 or 20 feet away, one of whom is, again, about 1 foot away the whole time, kind of hovering over the officer's arm, not nefariously necessarily. You don't think it's incumbent upon them in some way to just take a look inside and make sure whatever shot the person in the leg isn't still there, or that he's not going to, if he realizes, oh no, this is going the wrong way, even though he looks like he's in pain, we've all seen it before, people do amazing things, jump up and jump into the car and grab a gun and start firing. I mean,
I think part of—
and just look under the seat.
I
Say,
think part of the way that they were handling the scene, it kind of speaks to whether or not they had a reasonable fear for their safety. If they had arrived on this scene and they thought that this person had exchanged gunfire with somebody, or this happened there, or that he shot himself, then they would have they would have searched his vehicle, likely for a protective sweep that was justified. But here, there's no evidence of any of those facts. And what the Commonwealth's relying on for their probable cause analysis is what they don't know. And that's not what probable cause requires. So
What about a discharge of a firearm within 500 feet of a building, which is, what, 269-12E? I mean, you're looking at, right at the video, you can see it's a main street. He says it was right up the street. I don't think we have to take judicial notice, but Springfield and that area is pretty densely populated with buildings. You can see them on the video.
Well, we still don't know. You would be assuming that he's the one that discharged the firearm. You're assuming that it was within 500 feet of a building.
So either he discharged it, right?
Well, you would have to assume
Or
that.
someone else shot him.
And you would have to disregard the witnesses, the witness telling police officers that this was not at that location.
Right.
And that he's been shot.
No, he
So-
said it's right up the street. So can we not infer that right up the street there's other buildings that are occupied at 3:30 in the afternoon and that gunshots going off or people shooting guns, whether he shot it or the person who shot him shot it?
I think it would be a
Then you get a
leap.
crime either way, it seems.
I think it would be a leap, and you'd also have to assume that this is the suspect, that
Well, he doesn't have
committed
to be the suspect at that point.
Well, there still
because
needs to be a
He
nexus.
could be the victim of a crime.
And if
And there
he's-
could be evidence of that crime in the cars. There was certainly plenty of DNA evidence in there.
Understood when it comes to the blood evidence, but that's consistent with somebody who has been shot,
Right.
gets into their vehicle and leaves. There's no bullet hole in the car, there's no.
How do they know until they look in there to see there's no bullet hole in the floor or see there's no actual bullet on the floor or no shell casing if someone shot them and it spit out? That's, I guess, the question. Why isn't there
The doors-
probable cause? I guess what I'm trying to what I'm having a hard time with is you as, for example, a defense attorney. If they put the guy who's been shot in the leg on the stretcher, they leave and they say, okay, have a nice day, everybody. Car's running. That's it.
I don't
We're
think that's
gone.
the end
And then they don't do anything with the car. It doesn't seem like you might criticize that if.
Well, I think here they jumped the gun, though. I mean, the investigation didn't need to be over. They didn't need to jump to, let's do a protective sweep.
So what should they have done? He's
I
on the
think-
gurney, he's
Yep.
off, they don't want him to bleed out. They got all these civilians, you've got this car with blood everywhere. What should the police have done?
I think the wholeness case is the most reasonable approach here. And what they did there is they didn't search the car
I don't want to know
immediately.
I know what they did. What should they have done?
So they could have secured the scene, which they did, and sought a search warrant for this vehicle. They could have done more investigation. They could have gone up the street to see if there was some sort of shooting or other
Then
witnesses.
let's assume I agree with you. So then how does the automobile exception square with that?
I don't think the Commonwealth meets the automobile exception in this case.
So if they're
Yes,
getting a
there's-
search warrant, there's probable cause, right?
Well, based if they were doing more investigation.
So there's got to be probable cause. If you're saying they should get a search warrant, we presume there's probable cause.
I can't presume that there's probable cause, but they should, they should have done
Right.
more
But if you're saying that what they
investigation.
should have done is get a search warrant, then we have to, from that, it would seem to me, we have to go on the assumption that there's probable cause that there's evidence in the car.
There was
if you-
still more investigation that could have been done.
The car that's still running until after they find the gun and they reach in and turn it off.
Well, the vehicle, yes, the door was open, but he was parked next to his tow truck. And
You agree you can hear the engines running, and then after they find the gun and they lean in and turn the ignition off, and then they pull the key out and it starts dinging because the doors are open, you can hear the engine literally turn off.
they didn't need to leave the car running in order to, they could have
How do they go in
secured
and
the
turn-
vehicle, continued to investigate, talk to other witnesses. All they had on this record is that they arrived to a scene, he says, I've been shot. They have no idea who did it, where it occurred. I mean, there's just not enough evidence here in order to get them into that vehicle.
Did Justice McDonough say anything more about the automobile exception, save the one sentence where he says there's no exceptions, the warrant requirement applies here?
No, because the Commonwealth, they raised that in their motion for reconsideration. So they didn't raise it originally. They were relying on protective sweep and inventory.
He never made any explicit findings
I think they're implicit in his decision. The same reasoning that applies for why there wasn't probable cause applies to why there was no probable cause for the automobile exception. So I think he did reconsider. He considered their arguments. They made pretty much a repackaged argument about probable cause, and he,
Did he
again-
find no probable cause? Can you,
I'm sorry, what was that?
did he find that there was no probable cause?
Yes.
Okay. I'll take your word for it and I'll find it. I thought he found no threat and he found no inventory, but I didn't think he reached probable cause in his initial decision.
He's, in terms of whether or not there was probable cause to search the vehicle incident to any arrest.
All he said on the reconsideration in the margin is, I've reconsidered my ruling and reached the same result.
Right.
That's what he said on the okay.
Yeah, but in discussions of why he denied their, or rejected their argument, why it wasn't a search incident to arrest, that there was no probable cause for. And so really, I just, I think that the Commonwealth's brief is very telling, where it says, here's the 3 cases that we rely on for nexus. In all those cases, it's a driver of a vehicle who's suspected of a crime, who's coming from where the crime occurred.
Well, the blood was all over the driver's seat, right?
The blood was on the driver's seat, but that's not, I mean, we know whose blood that was. He came out of the car. It's not that we're looking for whose blood that belonged to. And if there was any other.
I'm sorry, I did interrupt you, but you were distinguishing some other case because that person was the driver of the car.
They were the driver of the car and a suspect of the crime that had been committed. So in Bostock, it was they stole from a vehicle, the car was found in the direction that witnesses said the car went. He was carrying a duffel bag and stole an Nextel cell phone. They get to the scene, there's a Nextel cell phone and a duffel bag in the car. All of these things connect the vehicle, the place to be searched, with the person who supposedly committed the crime. Wholeness, same thing. It was 2 different shootings he was implicated in. Got in a hit and run, and his car is 100 feet away with bullet fragments outside the car.
There's still a probability that either someone shot him, that's a crime, or and Justice Brennan said this before, or he shot himself, and that's a crime.
I think that in either of those circumstances, though, we're relying on too much speculation and conjecture. I mean, when it comes to if he was shot by someone else, which I agree is a crime.
That's the speculation, that he was shot by someone else. Why isn't that more speculative?
Because that's how the testimony came out, and there was no evidence to the contrary, that he was shot up the street by, and I also don't remember if he said by somebody else. He said, I've been shot.
There was evidence to the contrary, and that was the gun malfunctioned, the stovepipe malfunction.
Well, that would
I
be
learned
after
something
the
new
fact. I mean, that's not information that was found previous. I mean, I understand based on what they found after, that they are going to say that he shot himself, but that was at the time of the protective search is what we're looking at.
Could a
nothing
reasonable
after.
person in the officer's position infer from the location of the wound? It's kind of upper inner thigh angled. It's an odd spot to get shot if you're not holding the gun yourself, perhaps, or maybe not. Maybe there's no inference can be drawn from the location, what they looked at and thought, oh, shot
I
in the
think
inner
there was
thigh.
testimony to that effect, but there was no testimony about, because of the wound and the location that it was at, we believe that he shot himself. And so therefore, there'd be a firearm in the vehicle, and we have reasonable suspicion to get into the vehicle. But
Again, is the question whether the officers subjectively, personally believed that that was the case, or whether an objectively reasonable officer looking at the circumstances would draw that inference?
I understand it's the reasonable person standard, but here there's no evidence that prior to searching that he shot himself, whether that be the wound itself, and sometimes that requires expert testimony. And so I would argue that a reasonable person wouldn't say, oh, he shot himself based on the location it was at. People are shot every day in all different sorts of parts of their body. So, and if there are no further questions on these issues, and
Seeing none, thank
it will
you.
rest on my brief. Thank you.
Thank you both. We'll take it under advisement. The next case is 23P 1344, Commonwealth versus SHIMKOSKI. You should practice ahead of time. You should practice that. Mr. Methy.
May it please the court, my name is Attorney James Methy, and I represent Jeffrey SHIMKOSKI in this appeal. The first issue in my brief was that the evidence was insufficient to show that my client was criminally responsible for his actions. The DA proceeded in this case trial without any expert opinion by a doctor that my client was criminally responsible, and they proceeded on the basis of the facts of the case and an inference of sanity. And as you know, the defense presented Dr. Sternberg as a witness who had extensive knowledge of my client's mental health history, and including the fact that he had had approximately 10 psychiatric admissions for the previous 3 or 4 years, was released from an admission a week before this incident and was not on medication.
So it was an error for the judge not to credit the doctor's testimony?
Well, I would argue yes, because Dr. Sternberg is an unbiased witness in this case. He wasn't retained by the defense. He testified he was the court clinician for 20 years. So he's an unbiased witness in this case. And
Aren't finders of fact entitled to credit or discredit any piece of evidence, regardless of whether this bias exists?
Yeah, of course the judge can discredit anything that he wants to as far as the witness testimony.
And he apparently did.
Apparently he did. I just think it's unusual in this situation where he's the court clinician. If anything, he'd have a bias towards the Commonwealth, I would say.
That makes a pretty big assumption about court clinicians as a general, in general, that circulate around the court, but that's fair. That's a fair point, I suppose.
Can I ask you, we're looking at this in the light most favorable to the Commonwealth, right? So I want to just go through a list of facts, if you will, and tell me how we should consider those as we think about your claim. So he entered the bakery, he was dressed appropriately, he had on appropriate footwear, he had a valid driver's license, he ordered coffee, waited until it was ready, got the coffee, so something, you know, that I might do every morning. He was asked to leave, he left, he then came back in, was asked to leave again.
Well,
is it fair to infer that those are actions consistent with sanity?
some of those things you mentioned weren't actually testified to by the officer. They're in.
Okay, so which one should I exclude from my consideration?
Well, I guess you can't exclude them because they're in the doctor's report, and the doctor's report, two of his reports, the August report and the October report, were in evidence. So I can't really argue that you can't consider it. I'm just pointing out that it wasn't actually testified to by
But he goes to a coffee shop dressed appropriately and orders a coffee. He doesn't walk in a bikini in a snowstorm and order an elephant. I mean, I'm trying to figure out what to do with the facts that we have, and it's a small universe of facts.
I don't think there's a lot of facts here that would show that he was criminally responsible. Just the fact that he went into a coffee shop and ordered a coffee.
But I would agree with you. He has a mental health history. It's very clear on the record.
Right.
Having a mental health history does not necessarily equate to a lack of criminal responsibility. So I need to look at the universe of facts that occurred in and around the time before the dissemination of the obscene material. And when I look at the facts that I've just laid out to you, having trouble getting to the lack of criminal responsibility.
Mm-hmm.
So help me with that. Well,
I think what you don't have here is, I think, as I pointed out in my brief, the Lawson cases, I cited it numerous times in my brief, it seems to be the case on point here. And you look at the language from Lawson, they talk about planning, rational decisions, try to avoid capture, do not attempt to conceal, that kind of thing. There's nothing here that shows there was any planning. It's not a rational decision when somebody...
I don't mean to interrupt, but just, does it, when you say there's nothing to indicate planning, what about the fact that he waited until she walked to the back to go to the bathroom and followed after her? He didn't show her the video right out there at the counter. He did it sort of in what presumably is a more private place. Or can we not infer that? Or could the judge not have inferred that in some way?
I don't really think that that's planning. I think planning would be something that happened before the crime actually occurred.
What about taking a video of some sort and walking in with the video on his phone? Is that part of it? Or again, is that just more, who knows? Is that too speculative?
I don't think it's a rational decision also to do that, to show a video on your phone after a person says, you know, leave me alone, and that's somehow going to showing the video on his phone is going to somehow
Well-
change her mind.
Well, he clearly has issues. But the question really is, was he criminally responsible? And that test is hard to meet.
Right. Going back to the language again from Lawson, that there's no attempt to conceal anything or escape. The officer testified when he went to look for him, he was parked outside of the coffee shop. So we don't have anything like that.
And those are great examples of what would be better evidence that he's criminally responsible, excuse me. But that doesn't mean that what we have here equates to insufficient evidence.
Well, I see you don't seem particularly convinced. I just think it's based
Well,
on the Lawson case, I think it's a legitimate argument that the facts aren't here.
I'm not saying the argument's illegitimate. I'm having concerns about the argument, and one of them, which I didn't mention before, is Dr. Schoenberg?
Schoenberger.
Although he eventually says that he lacks criminal responsibility, he also wasn't able to really examine him in any particular way because the defendant had been in a car accident in which he had a brain event that prevented him from remembering anything that occurred, and would certainly weaken the credibility of his diagnosis.
Well, but I think the doctor did review the medical records up to the time of the incident, and the records indicated, as I explained before, that he was in rough shape at the time of the incident.
Did the doctor tie the defendant's hypersexuality, which apparently he demonstrated as part of his stay at St. Vincent's, to his opinion that the defendant was not able to to comport his conduct or to understand, I would imagine, comport his conduct to the requirements of the law, that aspect? Did he directly tie that? Because it would seem to me that hypersexuality and his behavior, there would be a logical link.
Right, he did talk about in his report about this improper sexual conduct occurring during one of his
On the
admissions.
floor, yeah.
So this seems to be now a recurring theme as to his conduct.
But he didn't specifically tie. He didn't say, well, one of the bases on which I am opining that the defendant was not able to comport his conduct to the requirements of the law is because he's got hypersexual tendencies, and look what he did. He didn't see that there.
Yeah.
Or is that just a logical inference that we should draw?
Yeah, I don't think I don't recall him specifically
Okay.
tying it to that.
Can I ask you about your second argument? There's no question that the witness used the word obscene, which is certainly an element of the offense, but where this is a bench trial and the judge is deemed to properly instruct himself on the law, what is the prejudice, even if it's error? What's the prejudice?
Well, I think that I don't think the witness is allowed to testify to that, and of course, there's issues about whether it's preserved or not. I won't get into that unless you want me to, but.
Why when I looked at it, she's not an attorney as far as the record reveals, that she was just speaking colloquially. People use the word obscene all the time. She's shown a video of a man masturbating. I mean, most people could immediately come up with the word obscene, even if they don't have a developed vocabulary.
Well, I think that's true, but I think in this particular case, when obscenity has to be proven, it's one of the elements of the case, and as I indicated, there's 3 requirements that have to be found before the judge can find that it's obscene, and of course, in this case, we don't even have a video, we have...
What rebuts the presumption that the judge instructed himself properly on those 3 elements?
I don't know what rebuts it. I would just point out that I don't think the witness should be allowed to testify that the video was obscene.
Yeah, there's weird stuff that happened in this trial, but
right.
it's a bench trial.
Right. Yeah,
Let me ask you,
it's a 40-page transcript.
It was opening gross lewdness, and the witness said, oof, it was really gross. Does that by definition then cause prejudice? Man, we know it has a legal, technical meaning, but as, I don't know. It's just as Meade just said, doesn't it also have a more colloquial meaning in can't we, or why shouldn't we infer that the judge was able to navigate that issue correctly?
Well, there were a couple of things that happened during the Commonwealth's witness's testimony. It was a little out of the ordinary. I would just state again that I think when the witness is asked, was the video obscene, and I don't think she can give I think it's a legal conclusion, or at least a question of fact and law together, and I don't think
Only
it's
objected to
proper.
the second time. The first time, she said it without objection.
Right, well, there's a kind of a weird, where the DA asks, was it artistic? And then he objects, the trial counsel objects, and then there's a back and forth, the judge is going to overrule it, and then the judge tells the DA, you can ask the question again, and then he changes the question to, was it obscene? So,
Well, literary and artistic value is evaluated by
Right.
the common standards of the community, of which she was a member. So I don't think she wasn't incompetent to say it lacked artistic or literary value. Common sense may just dictate that, too.
Well,
And
I
the
think in this-
grounds for the objection were that it was leading.
on the willful, not the prior.
So the question was
prior
the matter evidently obscene?
Right,
Witness responded yes. The judge allowed the prosecutor to ask on redirect. So he doesn't, on cross, they don't cross her on that. On redirect, the prosecutor asks
Right.
the witness, was it a willful act on his part? And she
Right.
said correct, and then the objection was as to leading.
right. That's the second part of
He
it.
didn't
yeah.
explore it on cross.
I don't even
So
know how
putting
does it read.
I'm going to go back to putting aside the question of whether it's preserved and whether it's error.
Right.
I'm stuck on the prejudice piece. Is there anything else you want to tell me on that?
Well, I just think, again, well, the willful is basically the same thing as the testifying that it was obscene. It's speculation as to my client's intent, and I don't think it's proper testimony by the witness based on the case law. I mean, as I cited,
She
In my
did
brief.
describe what she saw on the video, right?
she described what she saw, because there was no video and evidence, so my client's phone was never confiscated or no search warrant or anything, so. There's no further questions, I ask you to reverse the judgment.
No, seeing none, thank you. Ms. Borges.
Good morning, may it please the court. Danielle Borges on behalf of the Commonwealth. The Commonwealth respectfully asks this court to affirm the defendant's convictions. As discussed, the Commonwealth provided sufficient evidence that the defendant was criminally responsible at the time of the offense. And in this case where the judge, sitting as the trier of fact, heard the evidence and was not required to credit the expert testimony of Dr. Schonberger, and he was fully aware of both the defendant's argument claiming lack of criminal responsibility and the Commonwealth's burden to prove criminal responsibility, the judge was in the best position to evaluate the evidence on this issue and infer criminal responsibility on behalf of the defendant.
Was there any attempt to get the video?
To my knowledge, the prosecutor didn't plan to introduce the video.
It looks like he was released and then summoned. I didn't look at the docket that closely.
Yeah, yes.
Is that what happened?
Yeah, he was not arrested, yeah.
Yeah, okay.
Are there any questions on the first issue? If not, I can move to the second briefly. Just touching the defendant's second issue in his brief, the witness properly testified that the video was obscene and the defendant's actions were willful. As discussed, Mrs. Cummings' testimony regarding whether the video was obscene was proper. It was her own lay opinion. As Justice Meade said, she was using the term colloquially and not using it.
Can I circle back just for a moment on the first issue, which is, granted he went in, he ordered coffee, he got his coffee, he was asked to leave, he left, but then he came back, asked to leave again. It just seems to me that those could as easily be just rote behaviors, not necessarily indicative of a capacity to appreciate the wrongfulness of your behavior or to control your behavior in a very specific way, where again, he's just been released. I presume there was a 123-7 and 8 that was denied, and he was let out the door of St. Vincent's unmedicated and hypersexual and paranoid and schizophrenic. Yep, okay. So those individual behaviors, just tell me how they necessarily demonstrate sanity, if you will, as opposed to just somebody able to go through kind of rote daily behaviors.
So I think the judge sitting in this case was in the best position to evaluate both the evidence that the Commonwealth put forth and the evidence the defendant put forth in the form of the expert testimony from Dr. Schonberger. And the judge was able to not credit Dr. Schonberger's ultimate conclusion, even though it seemed undebatable that the defendant did suffer with mental health illness. Judge Abdallah still found that he was able to appreciate the wrongfulness of his conduct, based on what he was doing, which is what we said before. I know it's not, his actions aren't the only way to prove that someone's criminally responsible, but he credited his actions in terms of the crime that he committed, and he formed that was sufficient to prove criminal responsibility on the part of the
I
defendant.
mean, the valid driver's license, you say, it seems to me that who knows when he got the license and.
Sure. I don't think that's not the.
That's not you're not hanging your head.
That's not the strongest indicator of the responsibility,
fair.
but just, looking at the totality of it, it's an additional factor.
Okay.
Are there any further questions for the Commonwealth?
Is it proper to ask a witness whether someone else's conduct is willful or volitional?
So I think what the prosecutor was attempting to elicit and the witness to express was that he was acting alone. There wasn't anybody that was coercing him to do this behavior. He wasn't with friends who were, getting him to do a dare or something like that. It was just that he was acting on his own volition. So I think that's ultimately what the prosecutor was attempting to elicit in that line of questioning.
Seems like a teachable moment for the trial prosecutor.
I do agree. Yes, and for sure, but I think that was.
As to the other question, too.
Yeah,
Yes.
be better off asking about the circumstances from which you could argue that his conduct was volitional, rather than asking him to recite the elements.
Right, yes, will be reported back. There are no further questions. The Commonwealth will rest on its brief.
Seeing none, thank you.
Thank
you
you.
both. Yeah. There are cases in here?
Yeah, one of the lawyers is not
You're here.
You're here.
Yeah, they're here.
They're both here. Maybe they didn't sign in.
Yeah. The next case is 23P305, Commonwealth versus Otero. Welcome back, Mr. Corman.
Good to see you, Your Honors. May it please the Court, William Corman on behalf of the defendant. I recognize, and I was actually looking this morning, one has to go back a significant number of years in this Court's jurisprudence to find a case that is overturned based upon the introduction of prior bad act evidence and prior bad act evidence alone. One has to go back a very, very long way, and I get that. However,
See, I thought you were going to come in and argue the Harvey Weinstein case.
I thought of that too.
so
It's a good thing we don't have New York law
it
here.
clearly crossed my mind, who are we kidding? Having said that, the New York body of law is somewhat different than us here in the good old Commonwealth of Massachusetts. Regardless, I think defense counsel at trial said it best. How many more cumulative acts do we need? And
You know, at that pesky beyond a reasonable doubt standard is hard to gauge from the outside. And
Sure.
so it's hard to say what's too much.
And that's an excellent question and an excellent point, Your Honor.
Thank you.
And I think what we have in this case is, all of us who practice in appellate law, what we're really looking for is boundaries. What are the boundaries in each particular case? What are the boundaries in each particular decision that we then need to base trial work on? And I would suggest, respectfully, that this is one of those cases that radically pushes the boundaries of what a cumulative act and what a prior bad act should be. And, again, in this particular case, there was, with all due respect to my client, a significant amount of evidence regarding his actions involving the two victims. The two victims testified, first complaint witnesses testified, police officers testified as far as collateral and corroborating components.
So, Mr. Corman, I don't mean to cut you off, because I think you're going to give us a litany, which we know. The trial lawyer had a pretty tough mountain to climb. But doesn't that then go to what's the prejudice? If the case was so overwhelming and there was so much evidence that 2 extra pieces weren't necessary, then how do you get around then, well, then what difference does it make?
And that's the boundary consideration, Your Honor. Again, I'll draw an inapt analogy to closing arguments, right? We have overwhelming evidence, and yet prosecutors say things that they shouldn't say in closing argument, and collectively, respectfully, the courts tend to shrug their shoulders and say, the prosecutor absolutely shouldn't have said that, it was absolute error, I can't believe they said that, they should go back to law school, but the evidence is overwhelming, and therefore it doesn't change anything.
Mr. Corman, though, as you said, it's an inapt analogy, because the prior back evidence that came in was not an error, and we have to review it only for an abuse of discretion.
I agree, Your Honor. I agree. But again, getting back to what I said a few moments ago regarding the boundaries here, and as Justice Brennan said, there is a litany of evidence here against my client. And I suppose the answer to the question, which is, so what do 2 more pieces of evidence matter? I would suggest the answer is, I think they matter a lot. And it is these cases where the government has, I would respectfully say, a significant amount of evidence pointing towards guilt, where gilding the lily becomes inappropriate. And at what point do we say, I'm sorry, Your Honor.
Let me interrupt you. I have 3 questions. I think they're short. So my first one is, does his other conviction and a panel of this court affirming it on a similar argument in the other county have any stare decisis value in our case?
No.
Second question, don't we have cases that talk about requiring a judge to do exactly what she did here, which is she kept out some stuff and allowed other stuff in, and doesn't that show us that she properly exercised her discretion?
So my answer to that is the judge exercised some discretion, clearly by not allowing in absolute third victim evidence, but I think that my answer still is no. I think that she certainly excluded the one that I would have thought was way out in left field, but I think
the other victim that wasn't in this county.
But I think she should have gone much further and kept this out.
And then the third question is, we have 3 not guilties.
Yes, and absolutely. And my response to that is this. I think that, again, taking a giant step, it's a very macro day apparently. I think that when we are looking at what I would consider improper argument, improper evidence being admitted, the Commonwealth can't fall back on, yeah, but the guy was found not guilty of some stuff.
No, but if we're looking at that balancing test of probative and prejudice, and was it unfair, and could the jury be discerning, you have 3 acquittals.
Yes, but I think it's important to take a look at what the acquittals are. I mean, again, these are
3 rapes, right?
Yes, and these are multiple acts against multiple victims over multiple times in multiple locations. So what I'm suggesting to the court is there could be no evidence regarding a specific sexual act. The witness was cross-examined. They were a little contradictory as to what exactly they said happened on that instance. That leads to a not guilty, and I would suggest that has potentially nothing to do with the prior bad act evidence. It has to show the Commonwealth wasn't able to connect the dots in those particular cases. So I don't think we can merge the 2 and say because there were not guilties on charges, therefore the prior bad act evidence didn't factor into the jury's conclusion. That simply makes no sense, because one can imagine where, again, 15 charges and for some reason or another the Commonwealth skips over one because it's the hurly-burly notion of trial court. We can't then say that because the guy was found not guilty of one offense, the prior bad acts didn't factor into it at all. So I think my answer to all 3 of your questions is no.
Mr. Corman,
I did all my questions.
You mentioned,
well done.
You mentioned in your brief that the prior bad acts conduct occurs in Plymouth County, and this case, of course, is from Bristol County.
Yes.
But you don't seem to argue that made it improper because of the jurisdictional difference.
Oh, I don't think the jurisdictional difference
I just wanted to
matters
make sure.
at all. Okay. No, I think, no, it could have been the same county, it could have been a different state. I don't think it matters at all.
Putting aside the manner in which the judge exercised her discretion, do you take issue with her process? Hearing offers of proof, hearing arguments of counsel, laying out the law, whatever else she may have done. Any concern with the process in this case as opposed to just the result?
I think the judge followed the process and got the result wrong. And I do mean that. And again, as I started, this is a boundary issue, and as I set forth in my brief, 25% of the victim's testimony had to do with prior bad acts. 25%.
Of the second, of NC?
Yes, of a quarter of her testimony. So again, at what point do we say, yeah, yes, there's a lot of evidence, but nevertheless, these are the cases in which the Commonwealth absolutely should confine themselves to the appropriate case.
This relates to your argument or your claim in the brief that the testimony was not cursory or summary, but
not at all.
But is there any requirement that it be summary or?
No, but I think that goes to my argument that at what point does the testimony of the prior bad act overwhelm the testimony of the case that we're on trial for? Is it a 50-50 balance? I think 25% of the testimony is a heck of a lot, considering that that's not what he was on trial for.
Weren't they pretty much exactly the same acts with the same victims?
Yeah, but I don't think it matters. I don't think that the fact that it was the same victims and the fact the same act matters. Not in this particular case.
Even if, pattern of conduct, relationship of the parties, those don't inform the fact finder on those issues?
So again, well, first of all, the judge needs to find that it's relevant for something other than propensity.
Right.
And that the question comes awfully closest to propensity, in my opinion. So I suppose that's my answer to your question.
Okay. But the judge instructed on more than a few times that they can't consider it as propensity.
As did the Commonwealth during their closing. But again, I think that, at some point it's overkill. And I suggest that this is that case. I thank you for your time.
Thank you. Ms. Lee, welcome back as well.
Good morning. May it please the court, Mary Lee, Assistant District Attorney from the Bristol District for the Commonwealth. The Commonwealth relies on the very experienced trial judge's exercise of discretion here. We know she exercised her discretion because she kept out evidence relating to the third victim, which is similar to the ruling in the Harvey Weinstein case. It was the other victims. And I think that's significant. That's important because this is about what the defendant did to these girls, and the only distinction between the charged conduct and we'll call it uncharged conduct in Bristol County is that it was over the county line in Brockton where he lived. And there was a question earlier about the unpublished decision and what weight does that give. It's only for persuasive value. You're not required to follow it. So it's not stare decisis. But when we look at the rule of thumb that like cases should have similar results, this case is simply the flip of the Plymouth case. The charged conduct in the Plymouth case is the uncharged conduct in Bristol,
Is
and
there a
vice versa.
mechanism? Could you have tried them together? Could there have been an interdepartmental transfer so folks didn't have to testify twice?
Yes, and I think it's under Rule 9, and I think it has to be done at least with the consent of the defendant, but it might have to be on the motion of the defendant, because the defendant has a right to be tried
His county.
in the county where the conduct occurred, and so if it's not done properly, it's
With jurors that are drawn from that.
And in addition to that, you have to have both district attorneys agree that it's going to be tried in another county. So it can...
Those things never happen.
Politics.
No, it can and has been done. I've done it myself. You end up having people as special. So there's a lot of procedural stuff that requires it. Sometimes that's useful so you don't have to have victims testify twice. And actually at the beginning of this case, NC, who is the person who's the friend of the defendant's granddaughter, she didn't want to come in. And the prosecutor proffered she didn't want to come in because she'd done this already in Brockton. And the judge said nothing about NC is going to come in unless NC testifies, which is part of the reason strategically the defense was like, this is why we don't think the prior bad acts should come in, even though they're offering to null pros those, because it's the testimony about NC with the DNA in the back seat. She was the
What do you
person
make
in
of
the back
Mr.
seat.
Corman's, and pardon me if I'm paraphrasing it incorrectly, but piling on argument?
How much is too much? So I point to the Dwyer case, which gives us, this is way too much. There were more bad acts than charged conduct in Dwyer, and not a little more, a lot more. So as I was writing my brief, I thought it was important to point out where Dwyer should be looked at in the analysis. Here we have more charged conduct. We had 10 charges to start. and 2 prior bad acts. You could call it 3 prior bad acts because AH and NC are both involved in the Father's Day issue. So relevance of these bad acts is important, and so I think these bad acts are specifically important in this case in showing the nature of the relationship between the defendant and the victims, because the crayon incident, she's obviously young. This is AH. She's obviously young. She's asking for a crayon kit at the store, and he buys Vaseline at the same time and says she's going to have to pay for it. And then there's a sexual act occurring back at his house with the Vaseline. And that shows that that's early on in their relationship, which is also similar to, we know the first incident charged in Bristol is the babysitting in the mother's bedroom, and then there's one with a Hannah Montana blanket, so we know she's young there too. But crayons gives you a sense of it's towards the younger age, so that's towards the beginning of it. And then the Brockton incident, that's a prior uncharged conduct, is the last incident. NC never sees him again. 3 weeks later, she discloses.
That's the van.
That's Father's Day with the T-shirts.
That's the T-shirt, okay.
And the showers. So the van is the charged conduct.
Gotcha.
The unpublished decision shows there's a Brockton van incident as well. That's charged conduct in Brockton, and the Fall River ejaculating on the back seat
That's where we get
incident.
the crime lab.
Yeah, that's a uncharged conduct in Brockton, as I read the unpublished decision. I have not read the briefs in the Brockton matter, but reading that language, the ejaculation in the back seat with NC is Fall River, but it's seized in Brockton. And so the defense was trying to keep that out because it was seized as part of the Brockton investigation. So this was a case where those particular incidents kind of bookend the defendant's conduct with AH, and it shows the last date, so it's very relevant to the first complaint as well and how this conduct ended with the defendant. And so that's highly probative, and that's why I think it's distinguished from Dwyer, not just in counting up numbers, it's not a math thing, but in relevance to the case. So I'd ask this court to apply the standard of abusive discretion. The defendant has to show palpable error, and I would ask this court to find that none is found here and to affirm the convictions.
Thank you. Thank you both. We're going to take a short break, and then we'll hear the last 2 cases.
session to be proceeded.
Yeah, I was wrong.
Oh. Just remember that I'm always right.
No, you're not. Tuesdays.
I'm half left. The next case is 23P 1186 Sternberg versus the City of Newton. Ms. Basu, did I say it correctly?
Yes, thank you, Your Honor. May it please the Court, Krishna Basu for the City of Newton in this case. The issue in this case is whether the City of Newton should be found immune from suit under the discretionary function exemption of the Mass Torts Claims Act for the city's decision to maintain its sewer system according to a capital improvement plan. What the plaintiff is alleging in this case is that the city failed to maintain its sewer system properly. And the city has chosen this capital improvement plan as a $49 million initiative that was started in 2012 because of the sheer volume. The city's sewer system encompasses 284 miles of pipes, 24,909 private connections. And so they can't all be constantly inspected. And so the city has chosen to systematically evaluate, clean when necessary, and repair or line, if necessary, those pipes. And the city does this by using a televised camera to go through the pipes segment by segment. The city has determined that certain areas should be prioritized as to which should be done in which order based on the age of the pipes, the location of the pipes, any prior problems, and the flow monitoring results. And so this area of the city where the Meadowbrook Road, where the Sternbergs live, was scheduled to be evaluated in 2018 and was in fact evaluated in 2018. So I think the important thing to note is that the CIP, the Capital Improvement Plan, is the city's maintenance program, and that is what the city has determined is the best use of its resources to maintain the
Why
pipes.
isn't this like the Doherty case with the, where it was a ministerial maintenance obligation, and then your brother says that it's also a disputed fact whether it's ministerial or discretionary?
Well, I think that the Doherty case points out that maintenance can be ministerial, but it can also be discretionary, because in the Doherty case, the decision to cut down the pipes was a decision that was a discretionary decision. But in that case, what the court was focused on was then that a decision had been made that those pipes should then be pounded into the pavement to make them safe, and that decision was not carried out. So I think if the situation in this case were that Meadowbrook Road was a problematic area and that the city should have done that first, in 2013, and then that wasn't done and it wasn't carried out, then I think it would be more akin to Doherty. Or if there was a situation where the pipes were televised and there was a repair that needed to be done and then the city didn't do it, then I think that would be something that was not carried out and would be ministerial.
So you have the plan, the maintenance plan, and no one checked that the sewer in question for 5 years. Why isn't that failure to implement the plan?
Because part of the plan is the order and which areas should be done first. And Your Honor, I agree that if there was some time that had passed, but I think it's also telling that even if we assume as true as stated by the Sternbergs that there was a problem in 2010.
I think we have to, right? Because it's summary judgment.
Well, we don't know that the problem was in the city's system. We don't know that it was a problem with the city's system. But if we assume that it was, then it's telling that 2 years passed before the implementation of the capital improvement program and there were no problems. And then 8 years passed. So it's not a situation where there had been repeated problems with this line and the city didn't get to it and didn't in due course as they should have pursuant to the plan. And I think the other thing that's important to note is in looking at the Tarzia case or the Fortenbach case, the fact that there are prior problems that maybe even would be similar is not, doesn't conclude the analysis on the discretionary function.
So can I ask you on that? So you said, I think I heard you correctly, you said that if the city knew that it was a problematic area, then it might be a ministerial, is that right? Ministerial issue?
It could be if there was a decision made that this was an area that should be given prioritization and then it was not and it was carried out, or...
Assume for the moment, just work with me, assume that rather than just on the one occasion, the Sternbergs complained 6 times, or just said, well, you know, it smells, and now we got bad water flow, and now, I don't know, something going on with the pipes, I can't tell you what it is, but there's a problem here. And the city just says, oh, well, we've got our capital plan, and we'll get to it when we get to it. Does that make a difference?
It could make a difference, but I think still I believe it was in the I can't remember if it was the Tarzia case or the Fort Marker, he said there were multiple problems. And I think we still have to look at what was the plan and what was the reasoning behind the plan. I mean, I think if it was a case like the Nemec case where there was, you know, a hole in the pipe, then that might be a little bit different, but...
How would they know if they don't look?
Well, the city's plan, because of the sheer volume, is to go segment by segment with a camera to look at those pipes. And, you know, if there had been a problem that had been reported numerous times, then perhaps it would have been moved up in the priority, because that also occurs. And
there was no evidence that the 2010 problem related to rags or improper things in the drain.
Correct, Your Honor. We don't know what the problem was, if it was something that was in the Sternbergs in internal private pipe, or if it was in the city pipe. You know, we don't know any of that. And there's nothing about that in the record. So I would also like to turn to my second argument in this case, the city's second argument, which is that the city also should be found immune from suit under the public duty rule under Section 10J for the plaintiff's claim that the city had failed to prevent, because that is what the allegation is in the interrogatories and the complaint, was that the city failed to prevent this blockage from occurring. And the case law is clear that something has to be originally caused, there has to be an affirmative act, and it's undisputed that the city did not put the debris and rags into the system. The city didn't know about it. In fact, the city prohibits solids from being flushed or placed into the sewage system. And so I would turn the court's attention to the Clevin case, where the court held that we need to focus on what the claims are that are alleged. And here it was a failure to maintain. And the Clevin case also talked about the original cause cannot be having a sewer system. It can't be something that broad, because otherwise everything, nothing would be covered by Section 10J.
And it can't be something failure to prevent either.
Correct. And the plaintiff then argues, and the lower court looked at this too, that negligence of maintenance of public property is an exception to 10J in 10J3. And with that, I would turn the court's attention to the Moore versus Billerica case, which is also a case involving public property. That was a case involving a playground that was next to a ballpark.
Is that in your brief?
Yes.
Okay.
And the plaintiff claimed that the town of Billerica should have maintained the playground and the park better by putting up fencing or some kind of barrier.
Is this the baseball or softball player and the lacrosse player and someone got hit in the hip with the ball?
Right.
Yes.
Yeah, okay.
Yes, Your Honor. It was a baseball park that was next to the playground where the plaintiff was playing. And the court talked about how we can't have the 10J3 exception swallow the rule of 10J, because there's in many cases, or maybe possibly all cases, there's something that could have been done to prevent the injury. In the Brum case, you know, if there had been a warning or a protection to the student, in the Jackham case, that if there had been some kind of warning to the people that were at the beach. But we can't have...
The Lobster Pot case no longer good law?
Your Honor, it has not been overturned. It is a very old case. It is from
predates
1955. Yes,
statute.
it predates the Mass Torts Claims Act. But I would suggest that even in the lobster case, the court talks about how there's a difference in what a municipality can be liable for between planning and design versus maintenance. And I would say that the CIP, the Capital Improvement Program, is really more akin to planning because it's the way that the city plans to keep its sewer system from working efficiently. And so it really goes more to that than a simple maintenance issue.
So it seems to me that the effect, and I'm not saying it's necessarily incorrect legally, but the effect of this, if we accept your argument, is that if you live in the city of Newton and it's not in your side of the pipe, any kind of explosion of refuse into your house is your problem. Is that kind of the gist of what we'd be saying? Regardless, I mean, it doesn't seem right.
It could if it was something that was not, that was, very unusual, but there are...
Trying to fathom a circumstance that's not covered by the, at least if we read 10B as you'd have us read it under Fortenbacher. I couldn't envision a situation where the city would be liable for anybody's basement being flooded with sewage.
Well, again, Your Honor,
pipes.
I think that there are situations, for example, if the city had done its televised inspection, seen, this area is rusted out, there's a problem with this area, there's, a leak like in the Nemec case, and then the city didn't follow through with that, and that was the cause, then I think that there would be an exception, that the discretionary function would not apply. So I think that that's the kind of situation. It's not an overall, we have to look at, as the case law has said, we have to look at the facts and the allegations and what is the alleged harm in the case to determine whether or not the discretionary function applies or not. And so I would like to also just leave the court with that the purpose of the discretionary function exemption is to allow municipalities throughout the Commonwealth to make these kind of broad policy decisions. And as you can see from the record, this CIP plan involves millions of dollars, involves making a lot of decisions about, what's the best way? Should everything be flushed every day? Every pipe? Should, the televised camera go through every day? And the cities and towns have to make decisions about what they're able to do and what's the best way to maintain the sewer system. And so that's the reason that the discretionary function exists, so that those decisions by the government entities will not be second-guessed by the courts.
Thank you.
Thank you very much.
Mr. Pitti.
Thank you. Good morning, Your Honors. May it please the Court, Jason Pitti for the appellees, EDGARDO and Ailette Sternberg. With me in court is actually Mr. Sternberg. Justice Brennan, you asked a question, and I think it's a very important one, which was how would they know if they don't look? And that's the city's approach here. The city's approach here, and with all due respect to my sister, they continue to argue that this SIP plan is a maintenance plan. The lower court found that the SIP plan was not a maintenance plan, and the lower court further found that the Sternbergs weren't arguing that it was a maintenance plan or not, and that this was, the issues here were not because of the...
I'm sorry, help me out then.
Sure.
I thought it was a capital improvement plan to see where sewer areas needed maintenance or repair.
No, it was a capital improvement plan to either repair, replace, or reline the sewer lines in the city of Newton.
Where areas were damaged, right?
No, throughout the entire city. As she testified, there's 284 miles of sewer lines. Their intention was to do work in all 284 lines. So that's not maintenance per se. That's a complete plan to redo everything. I would liken it to the situation where a municipality decides to resurface all the roads within that municipality. It's going to take 10 years to do the resurfacing. while that plan is in place, that resurfacing plan is in place, it doesn't mean that the DPW or the municipality doesn't still have an obligation to maintain those roads. They still do. And that's the issue with the city of Newton here, is that their position that they've taken is, look, we had the SIP plan, it cost us a lot of money, we were proceeding in an orderly fashion. Yes, it took us 6 years to get to the Sternberg's property, but that's what we were doing. And
Well, why isn't this case controlled by Cleven then?
it's not, because of the fact that in this particular set of circumstances, number one, we argue that the SIP plan, so we're not arguing that the SIP plan is the discretionary function that's being engaged in. The discretionary function that we're talking about here, the plan is this reactive maintenance plan that the city of Newton engages in. And they admit that, in their own pleadings, and the lower court found that it was a reactive maintenance plan that the city uses. When a problem arises, the city of Newton will then go out and attempt to fix that problem, okay? So the issue is not the SIP, it's the reactive maintenance plan. That's number one. And the reactive maintenance in and of itself is not a plan. That's we're going to fix it when it's broken. It's not, we're going to maintain it, we're going to inspect it, we're going to clean it, we're going to flush it. And quite to the contrary, you can see in the facts of this case, after the Sternbergs have this major backflow of sewage flow into their home, destroying significant portions of the lower level of the home, placing my clients in danger from the sewer effluent. It's at that point in time that the city then puts us on the flushing list. And it's at that point in time that the city then starts paying attention to Meadowbrook Road. It's at that point in time that suddenly, almost 2 weeks later, here they are with the SIP plan, and they're proceeding with the SIP plan.
So you don't, I'm sorry, go ahead, just, nope. So you dispute then that this was already part of the overall plan and it was just a worst luck in the world that 2 weeks before they were going to get to it anyway, this occurred?
I'm sorry.
Yeah, my understanding was that at least in reading it, maybe I misread it, that part of the capital improvement plan called for that pipe, if you will, to be looked at. It just happened to be coming up in 2 weeks.
Yeah, that's exactly what happened. That's right.
So it wasn't just because of this.
No, I didn't mean to suggest that, Your Honor. I didn't mean to suggest that.
I may have misunderstood.
It was that it just happened to be 2 weeks later, there they are. 1 year later, the relining of that manhole cover and the sewer line outside of the Sternberg's property is in fact completed.
You assert in your brief that the blockage had to have accumulated over time and couldn't have been spontaneous. Where do I find that in the record, though?
Well, Your Honors, quite frankly, we don't have to necessarily prove that the blockage accrued over time.
But you argue that.
I do argue that.
I'm just trying to find support for that in
well,
the record.
I think that the support for it in the record is in the report from Dr. Drain. When they go out and they inspect the sewer line, they found it to be completely and totally blocked. So in order for a problem of this magnitude to happen, Dr. Drain and the city also, and this is in the record, they inspected the manhole sewer cover lower than the property, downgrading from the property that evening or that next morning. It was dry. There was no water flowing whatsoever.
So you're making an inference that it accumulated. I don't have an expert report in the record that tells me that, right?
No, and quite frankly, we never even got to the stage of designating experts.
And you attach two things to your brief that I know what you argue, but you understand the rules preclude us from considering anything that wasn't in the record below.
I understand that, and I would just submit that the only reason that they were included was because of the fact that for the first time in the brief of the city of Newton, did they raise this issue that there was nothing wrong with our pipes, with our sewer lines.
But you didn't file a motion to expand the record or anything?
I did not, and I acknowledge that. And I don't think that we need that to be able to succeed in defense of this.
Is the question of whether 10B applies a question of law?
The question of whether 10B applies is a question of law?
And 10J.
And 10J, I was going to get to that next.
No, well, 10J, no, for sure, especially when we're talking about the exception to 10J that exists in the lobster pot case. The issue of 10B could be a question of law. The problem is that we have divergent positions that are being taken as to what is the plan and what is the maintenance plan for which we are complaining about. The city of Newton takes the position that the SIP is the plan, and that we are arguing somehow that the SIP wasn't an appropriate remedy or maintenance plan.
Well, all right, so that's 10B. Let me ask you about 10J.
Sure.
You write in your brief that it's undisputed that the city was the original cause of the backup, not the rags. You said the city can't claim that its actions were not the original cause of the backup on the property.
Right, that the city cannot claim that the backup was the cause of the problem? Yes, I agree with that. I didn't, wasn't suggesting that the city caused the backup. What we suggest is that the city could have prevented and...
Let me try again. You wrote that the city cannot claim that it was not the original cause.
Right, because they have provided, there's nothing in the record to reflect that this was...
Your contractor said it was the rags that caused the backup.
Understood, but...
Understood is that the city can claim that it was not the original cause of the backup, because your contractor said the rags were the cause of the backup.
Understood, but if the city had engaged in any level of inspection or maintenance in the area...
Well, okay, so that goes to the rest of 10J. So that's the failure to prevent a harm that the defendant, the city in this case, was not the original cause of, but that of a third party, unknown, not the city. That's immune from suit.
Which then you have to look to the exception that exists in both the lobster pot case and then the law arising out of the lobster pot case, this court rulings in the Nemeth case, all of which stand for the proposition that the negligent maintenance is an exception to 10J. That if there is negligent maintenance that is alleged, that it is an exception. And
well, it has to be more than just alleged, because this is summary judgment.
Understood. And the facts as it relates to that, Your Honors, are, number one, there is a 2010 incident where septic flows back into the property. That is affirmed by Mr. Sternberg's affidavit and his answers to interrogatories. That is uncontroverted. Now, the city says, well, we don't know what the cause was. Well, that's because they didn't do anything with regard to it. They never came out and inspected it. They never addressed the issue. So number one, the 2010 incident. Then we have a period of time of a minimum of 5 years. I believe it's actually 8 years, but let's just focus on the 5 years that the city has acknowledged, that there is zero maintenance or attention to the sewer line on Meadowbrook Road during that period of time.
But if the failure to prevent the risks to the property was not the original cause, then 10J3 doesn't apply.
If the failure to prevent the risk associated with the property, then 10J would not apply.
Then it's not a failure to maintain problem. In other words, the failure to maintain did not cause the blockage.
Right, but we would argue that it absolutely is, that there is enough evidence, as the lower court found, there is enough evidence.
Well, she didn't find anything. It was summary judgment.
Well, the lower court indicated that the facts that were before her were sufficient to at least put this issue before a jury and not an issue that was appropriate at summary judgment, because we were doing a garden variety negligence analysis. Is there a duty?
Yeah, you know, and the city makes an excellent point in the reply brief that they're not saying they weren't negligent. That's not the basis of their defense. Their defense is that even if they were negligent, this type of negligence isn't something they can be sued for. That's what immunity is all about.
Right. But negligent maintenance is an exception to the immunity.
I know we're going in circles here, but the negligent maintenance did not cause the blockage. The rags caused the blockage, of which the city was not the original cause.
But, well, I think what's happening is I think that we're combining the 10J with the city being the original cause, and then we're not completely taking the exception, which is an exception to that, which is negligent maintenance. If negligent maintenance is the reason for the cause of the harm, then the immunity will not apply. And the Sternbergs have made that allegation. It is undisputed based upon the record that the Sternbergs...
We're not here in a motion to dismiss, though. So you need evidence to support the allegations, or an inference in the light most favorable to you. And your own expert says that the rags caused the backup. And let me ask you this, because maybe I misread your brief, but you seem to think that if the 10J3 exception to the limited waiver applies, then that wipes out any 10B discretionary function defense as well.
No, that was not the argument that was made. I believe that we handled the two things have to be handled separately.
You could read the judge's decision that she thought that was the case.
I think that the judge jumped over a step in her ruling. But I think that she properly found what she did was Doherty stood for the application of 10B immunity and also the application of 10J immunity and the exception associated with it. What the judge...
So she was wrong then about that part.
No, not wrong. She did not, what she cited to 10J Doherty when it was a 10B Doherty argument. That was my position.
No, what I'm saying is that a 10J3 exception does not wipe out a 10B immunity defense. It says so in that nifty Fortenbacher case.
I understand that. And our position is that if you take each one of the arguments, the 10B argument and the 10J argument, that we have submitted enough.
No, I understand, but I'm saying the judge conflated the two improperly.
Well, I do think that the judge still ultimately in her full analysis of the public duty rule that she considered all of the 10J application, she considered 10J, she considered the exception to 10J.
Before we run out of time, jump back to 10B. The bridge in Fortenbacher, like the sewer system here, where there was at least one reported concern 5 years prior, the bridge in Fortenbacher had years of issues with it, and they did makeshift repairs, or piecemeal repairs, I should say, over the years. And that still didn't affect the fact that it was a policy-making decision to how to carry out the repairs.
And in this case, they did nothing. They did nothing. The city has absolutely zero evidence of doing anything on Meadowbrook Road for at least 5 years prior to that incident. And I would submit that that in and of itself is negligent maintenance. The city put a plan together to replace the entirety of the sewer system and then sat back and did nothing. And I understand the situation in Fortenbacher, but this is different. They did nothing. They have no evidence of doing anything. And look at what they do after we report the problem. All of a sudden, now we're on the flushing list. All of a sudden, now they're out there every month flushing. So, thank you very much, Your Honors.
Thank you. Thank you both. Take it under advisement. Our last case is 23P1169, Department of Children and Families versus Mother and Another. No, that's fine.
AJ. After we take a recess, will you bring Sydney, who's in the back into the room? Thank you. Okay.
As you all know, this is impounded, so no names, descriptive titles, or initials. Or Ms. Krasner.
Thank you. May it please the Court, Sherry Krasner on behalf of Mother. My client is watching the argument on live stream from her home in Western Massachusetts. The Court must vacate the termination judgment here. My certainty is based on the I'm so sorry. My certainty is based on the answers to two simple questions. What did the trial judge know, and when did she know it? Because at the conclusion of trial in February of 2022, the trial judge did not know, because she was not told, the clear contours of DCF's permanency plan for the child. The judgment that she entered at the time is void.
So I want to stop you. And I'm going to talk to DCF about the testimony, which is, thinking about the last case, muddy at best. Why is it, if you're right, that the plan is at issue, or the evidence about the plan and the ultimate decision in the decree is at issue, I don't understand why that's not a remand on the plan and why you say it's a vacatur of the termination.
The court, thanks for the question. The court may be thinking about adoption of VARIC, because that's what the court did there. And what makes this case different than VARIC, VARIC was a written, underdeveloped plan. In this case, there was no plan. In VARIC, there was a sequential plan for, they were going to look at ICPC, and if that didn't work, then they were going to do recruitment, but there was someone else they were thinking about. So the contours of what the department wanted to do were laid out there. What this court said was, but there's still not enough detail about what kind of home, what kind of environment this child needs. So quite frankly, I think in VARIC, they were trying, the appellants were trying to make the argument there that I'm making now, but I think in VARIC, it didn't work because, again, it was an underdeveloped plan as opposed to no plan. I mean, here...
And so you're not, because I was curious to see your reply brief, so thank you for filing that. You're not suggesting this is a competing plan, and we had a fully developed ICPC for Connecticut for the brother. In fact, we know that that didn't end up going anywhere. You're saying, if I understand you correctly, that if the plan was adoption with the current foster family, pre-adoptive family, there wasn't any evidence of that. There was this really oblique question and answer, and that was it. There just was, to borrow a term, insufficient evidence of the plan. You're not saying that the judge erred in considering competing plans.
Correct.
So let's suggest that I might agree with you. The record is thin. I don't understand why it's a reversal of the termination, why she gets a new trial on termination. There may be a reason to have a new trial on plan, but I'm really stuck on the termination piece. You've got to help me.
Because, again, when the judge issued her decision in 2022, what was she approving?
Well, I think you could infer, right? Because if you look at page, well, I have it attached to your brief. I know it's in the appendix. At your brief, it's at 84. Paragraph 5, it says, and I get that this is as thin as can be, the plan of adoption propounded by the department serves the child's best interests. And if I look at her findings in the totality of the circumstances, I can infer that that plan is adoption by the current family, particularly where, unfortunately, this child had been in and out of foster homes. They had to find a specialized foster home to deal with this child's unfortunate special needs. And so it may not be as bold and detailed as we would all like it to be, but I don't know why I can't make the inference that the plan was pre-adoptive family adoption.
Because, respectfully, I don't see how you can make that inference. Because, I mean, think about what the department did. They were so evasive, and I don't mean to use that in a pejorative way, but there was no written plan. This was an adoption worker, 25 years of experience, and the language that she used she never said the department is proposing. She said this family has put themselves forward.
Right.
And even at the conclusion of trial, and I know that the representations of counsel are not evidence, but the department's attorney represents the department, and she talked about the fact, well, there are two possibilities here, so please consider, if you're going to allow for post-termination, post-adoption visitation, please remember that there are two different possibilities that are on the table here. I mean, counsel wouldn't say at the end of trial, well, please consider you might decide to return this child home, so please also consider including a plan of transition back home for this child. That's not how counsel would ever frame the issue. So as representative of the department, she was suggesting there are two completely different options that are on the table. And we, at some point in time, will make that determination. And that simply is, we know from Dora, that is simply not something that the department is permitted to do.
Do we have any cases, I'll ask first published and then unpublished, where the record evidence of the plan was vague at best, and we did not vacate the termination, but we remanded for further development of the plan?
I mean, again, just Varick, and
Other
again,
than
just...
And I understand how you've tried to cabin that to its facts.
And I would say that the unpublished decisions that were cited to by the appellees were all, again, competing plan cases where the parents, or one of the parents had a plan and the department had a different plan. But that's not, again, that is not the case here. Here it was the department.
Another hypothetical for me.
Please.
Let's assume we remand on the plan only, and we don't vacate the decree of termination. Is your client entitled to participate in that hearing?
Well, absolutely, she gets that, and that's adoption of Zach. She would participate in that hearing, but
And you claim there's a due process violation because there was insufficient evidence of a plan.
Right. And as required by statute, that the judge has to consider both whether unfitness will continue indefinitely and meaningful evaluation of the plan. Again, the judge here, she could have, under cadence, she could have said, the plan that I am approving, I think what would satisfy this child's best interest is adoption by his current foster family. She could have done that. I'm not arguing that she didn't have the authority to do that, but she doesn't do that. She says that the plan propounded by the department meets the child's best interest, and there simply was not a plan. I also, going back to Varick, and again, arguing that Varick is not controlling, but if the court is going to be thinking about that, something else in Varick that the court talked about just how unfit the father was in that case and how overwhelming the evidence of unfitness was. That certainly is not the case here. In finding number 44, the judge talks about mother being in substantial compliance with all the tasks on her action plan, and there are a variety of findings following that finding 44 where she talks about just how all the things mother had accomplished. And in finding 108, the judge finds that the department's only protective concern about this parent was her relationship with father, and I think that the evidence upon which she relied to say that the relationship was still fraught with violence is not supported.
Ask you another hypothetical.
Please.
What if the judge had, what if the evidence had been more fully developed at trial about the pre-adoptive family wanting to adopt, but the adoption social worker testified that they were continuing to pursue the ICPC. It was in Virginia, not Connecticut. I apologize. And the judge said, something to the effect in her decree. She terminated and said, I'm going to have a further hearing once the ICPC is conducted in Virginia, and then let's say that fell through, and then she said, okay, I'm going to approve the department's plan. Would that be a problem?
No, I mean, I think that's exactly what she should have done. I think that's what Dora calls for. I mean, that's what she should have done. There was evidence, it was pending. There also...
We don't find out that the ICPC has basically fallen, or that plan fell through until your motion for post-judgment relief, or not even? By the time
Coincidentally, we found that out, but when I filed my motion, I did not know.
But before the hearing on that, did we know?
Before
the hearing, because she had a hearing on your motion.
Correct.
So when did the judge know at the time of your hearing that the ICPC had fallen through?
Well, the ICPC, it didn't fall through.
Oh, right.
I mean, I think that's important, too.
Let me say it differently. It wasn't a viable option anymore.
Although, if I can, I mean, I think that's important. It's not that it fell through. They were approved by the Commonwealth of Virginia, and then there were some issues that surfaced later on.
With the brother and the wife.
But those were exactly the kinds of issues that, had the judge done what you proposed, that she deferred the entry until that happened, then all of that would have been part of one proceeding in which mother would have had the right to participate. So, yes, Your Honor, I think that's exactly what a hypothetical that should have played out.
Did you ask the judge to take evidence on your post-judgment motion?
I'm sorry?
Did you ask the judge to take evidence on your post-judgment motion,
did
or was
not.
it just rep of counsel?
It was just argument by counsel. And I did not know, my client did not know about what had happened in Virginia until we got the response to my motion. So that was when we even discovered where we were. So again, it didn't play out in the way that it should have, where mother had a due process right to participate in which plan was appropriate for the child. And also just going back to the Varick argument, which again, I don't want it to be considered, but I can acknowledge that the court might consider it, and thinking about the overwhelming unfitness of mother, which we say did not exist. The appellees in their brief seem to suggest that there were police responses to mother's home concerning father in December of 2021, and I just want to set the record straight that that is not what occurred, and I would specifically direct the panel to Record Appendix Volume Number 1, between pages 274 and 281, that there were police responses. They were not related to father. Father wasn't present. They were responses that were related to the disputes that were going on between mother and her neighbor. So again, I just read that testimony between pages 96, starts page 96 in the transcript and goes on for the next several pages, talking about or skirting around what might be proposed for this child. And it's so vague, it's so ambiguous, it's so not clear that there are no circumstances in which this court could find, I would respectfully suggest, that there was a plan that the judge could approve as being in the best interest of the child. So again, I would ask that the entire termination judgment be vacated because the judge did not comply with her clear statutory mandate, with case law set out in Dora, in Stewart, and in Thea, and not contradicted by adoption of Varick. And I see my time is expiring in 20 seconds, so I'll rest on my brief. Thank you.
Thank you. Ms. Arslanian.
Members of the panel, may it please the court, Vanessa Arslanian, Assistant Attorney General on behalf of the Department of Children and Families, and urging affirmance of the juvenile court's decisions below. One reason vacatur would not be appropriate in this case is because there was overwhelming and evidence of mother's unfitness, and accordingly, I'd be happy to address any concerns that the court has about that finding by the juvenile court. But to recap that, the juvenile court found...
Because you're splitting time, and I know you have less time than
Yes.
normal. I really am struggling with, you know, I said it earlier this morning, practice tip for trial lawyers. This was not a fully developed record, in my view. It is thin. I think you're asking us to make lots of inferences that you asked the judge to make below. Putting that to the side for a second, if we agree with Attorney Krasner that it's insufficient as to the plan, tell me why she's wrong, that it's not a vacatur of the termination and it's solely a remand. And if it's solely a remand, does mom get to participate?
Yes, so Your Honor, we think that Varick is on point here, and our view is that the department's plan was more developed than in Varick, where the child was not yet in a pre-adoptive placement at that time. And
What's so different in Varick, right? It was almost like a laundry list of potential places. He could go here, he could go here, he could go there. Here, it's clear that, you know, the ICPC was pending and that the child had been in a specialized foster home after being in a number of placements that were unsuccessful. There was a lot of uncontroverted evidence about the foster family's home. All seemed great, but they didn't connect the dots.
Yeah, Your Honor, we certainly agree that the department could have been more clear and the court could have been, or I should say they could have been more express. We do think it's clear that this is what the court understood the plan to be. We think under the adoption of Nancy, this court can infer from the factual findings made by the court, those are at 99 through 106, that describes, and again, the standard here is, does the adoption plan describe the type of adoptive family and the home environment proposed by the department? And in the case of, for example, when the department is seeking adoption by recruitment, you need that in general terms, right? A two-parent household, that sort of thing. Here, it's not expressly stated and agreed. It would be better practice for it to have been. But we have, as you noted, the child had been in the placement, had bonded with the placement, had significant behavioral needs that were supported and were improving with the placement. Further, the court found in conclusion of law 18 subsection 7 that the child would suffer severe psychological harm being separated from that family. So we think it would be appropriate for this court to infer from the totality of those findings that that plan was sufficient. We also think that, and that's under adoption of Nancy. We also think that even if this court were to find that error was made at the trial, we think that the post-trial proceedings correct that error, where at that point, as you noted, the status of the department's finalized plan, and we think that at this point it's a final plan, not a competing alternative plan, is that we're going with the pre-adoptive foster family. The uncle is foreclosed as an option. At trial, there was suggestion and evidence before the court that the uncle's family was not fully cooperating or timely cooperating with the ICPC process, which is why it was delayed.
The wife, really.
The wife
so
wasn't.
Much the uncle, it was his wife.
The wife wasn't, and there's also some of the permanency, the 29B reports that later come detail. So this is after trial now. You're correct that at trial, it was that the wife did not participate, and that's why the extension was requested. After trial, we see that the ICPC is approved, and then there are a lot of hurdles just trying to get the uncle to and his wife to visit with the child. Things like basic, virtual visitation, things of that nature. So it expires in October of 2022. The post-trial motions filed in March of 23. There's been no change at the time of the hearing in June of 2023. And it's at that time that the court says, essentially says, I chose the pre-adoptive foster family as the plan. And I'd note also, even if the court were to find, well, the department's plan was pre-adoptive foster family, and they're looking into this other option, which they view themselves to be committed to do under their regulations to pursue kinship placement because, of course, as this court well knows, circumstances can change with a child or with a family. Even if we think the court chose a different plan or a subset of the plan propounded by DCF, that's permitted under Hugo and under Cadence. We think the question before the court is what plan is in the best interest of the child, and here we have at the post-trial stage, the court has clarified this is the plan that I think was in the best interest of the child.
So, but going back to my question, if for some reason we were to disagree with you, and you say this, I think, at page 46 of your brief, even if it's a remand, not a vacatur, why is that? And if we do remand, is mom entitled to participate?
Vacatur is only appropriate if, in a couple of circumstances. One is under DORA, if there are two competing plans set forth, the court doesn't consider or leaves to the discretion of DCF. Mother, although she relies on DORA, says this is not a competing plans case, so we're well out of the heartland on that case. The other is if there is no plan at all, and mother relies on the case of adoption of Thea, which very, very different from this case. It was a high-risk individual or child who was institutionalized at the time, was approaching 18, and the department said there are many, many different possibilities for the child. So there was really no actual plan for the child in that case. So that's why those are the circumstances where vacatur would be appropriate. Here we think at most adoption, remand on the issue of adoption is all that's needed. We also know, as I've stated or suggested, that would be not futile at this point because the uncle's option has been foreclosed. And whether mother could participate, we think not because her rights have been terminated. And there is certainly, at the very least, no need to revisit the unfitness determination. I'd also like to note on mother's due process claim with the last few moments that I have is that mother she was on notice that this family had come forward as a permanent resource since about 6 months before trial. Of course, there was questioning about this at trial. Mother's attorney did not cross-examine about the nature of the adoption plan. She did not request continuance of the trial. She did not try to put in any evidence about a competing plan, and nor does she dispute any of the findings even now about the suitability of this family. So if there are no further questions, I would turn this over to Child's Counsel.
Thank you.
Thank you.
Ms. Kornblue.
May it please the court, Deborah Kornblue representing Child. I want to start by following up with 3 questions that Justice Blake had. First, you had asked about another case that was similar to Varick. Just so you understand, we are not asking for a remand on anything, but the other case that was similar was an unpublished decision called Adoption of Armand, and that was decided by this court on February 15th of this year. But the big difference between Varick and Armand and this case is, in this case, it is implicit that the plan, if nothing else came forward, was the home in which my client, now almost 8 years old, who has been in this same comprehensive foster care home for 4.5 years, was thriving. I mean, there were findings about that. It was uncontested how well he was doing.
So let me ask you this. At page 96 of the record, which is page 69 of the permanency hearing, question is asked, can you describe to the court what the plan for Z is? Answer, the plan for Z is adoption. Okay, and other than the current home where he is there any other alternative that is being vetted presently? Answer, yes, there is, and then they go on about the ICPC in Virginia. So is that enough?
No, that's not enough. I mean,
you don't think that's enough for the judge to infer that the plan for adoption is with the current home? Other than the current home where he is there any other alternative that is being vetted presently?
Well, that in conjunction with the post-trial decision would be.
Okay.
I mean, and it's implicit. I mean, the court had ample detail about the home, the makeup of the home, the environment.
So it's a poorly phrased question and answer at the end of the day. That's what this all boils down to. If the adoption worker had said the plan for Z is adoption by his current foster family, I'm sure Attorney Krasner would raise other issues, but for this issue, that may have foreclosed it, right?
Right. And surely, as counsel for DCF said, both DCF and the court could have been, yes, we choose this particular plan. However, it's not what the case law requires. The case law requires sufficient information and detail about the type of home that...
We have that.
Right, and you have that, and the child was already in that type
We
of
just
home.
don't have the answer that says, this is the home for Z.
But you don't need that. You don't need that. And I also want to just follow up that on something that Mother's Council said to you today, and that was there's, this huge difference between Varick and this case regarding the unfitness determination. Not so. In this case, it was worse. It was worse than the father in Varick because you have a mother who goes through all of the steps that she has to go through on her action plan. She technically complies. She gets the certificates. People certify that she completed the plan. And at the end of the day, she is in exactly the same position in 2022 that she was in April of 2019 when DCF had to remove the child because despite all of her participation, she's with the father. It's uncontroverted. So clearly, no matter, that amply satisfies the criteria of 210 Section 3, where, there's going to be a continuing pattern, a continuing set of behaviors that show unfitness, because it doesn't matter how many programs she attends. So that's number two. And just to clarify something else that you asked, Justice Blake, yes, by the time of the hearing on Mother's 60B motion in March of 2023, based on the uncontroverted documents that child, through me, filed in response to Mother's motion, everybody knew at that point that the ICPC had expired. Nobody asked for a reapplication, as the regulation would have allowed, and nobody asked for DCF to reopen the ICPC. So at that point, everybody knew that it had expired. So at this point, to remand even on just that issue would be futile. It would just delay permanence for my client, because a remand would be the same thing. I mean, the mother never put in any type of evidence, as did, where was it? The mother never put in any kind of evidence, as did the party in Dora, where there was ample testimony about the out-of-state relative. In essence, the overarching principle in these cases is the best interest of the child. The ICPC lapse and the failure of the court to be able to consider the interstate compact was a lack of motivation on the part of the uncle and his wife, and I know that Justice Blake, you said it was really the wife, but it doesn't matter because they both had to be certified, they both had to be licensed.
We're going to have to leave it there. Your time is up.
Thank you, Your Honor. We would ask that you affirm both decisions in total.
Thank you.
Thank
you
you.
all. That'll conclude today's session. I'd like to thank our court staff, our clerk's office, our court officers, our law clerks, my panel, and the